Hello, I'm Attorney General Rob McKenna. Welcome to the Attorney General Office website and to our pages about the healthcare lawsuit. As you may have already noticed, we've provided updated, frequently asked questions and answers regarding the healthcare lawsuit. I hope you have a few minutes to peruse those. Let me just give you a brief summary of what's new on the website at this point. Number one, we provide an update to the status of the lawsuit, which is now in the 11th Circuit Court of Appeals. That circuit covers Florida and Georgia, and the case will be taken up by the 11th Circuit at in its courtroom in Atlanta, Georgia. We've asked for the 11th Circuit to expedite this case, and the Chief Judge has agreed to do that. So it could be heard as early as the beginning of June of this year. If that happens, it's entirely possible that the 11th Circuit opinion will be out in time for appeal to be taken to the United States Supreme Court in the 2011-2012 term. And in that case, the Supreme Court will probably rule by the end of June of 2012. On the other hand, the 11th Circuit could take much longer than that to actually issue its decision, and we might be looking at the 2012-2013 term for a Supreme Court decision. At the same time, however, the state of Virginia, which is pursuing its own case separate from the Florida case, which involves 26 states, including Washington, and Virginia's case, which is already in the 4th Circuit Court of Appeals, is also under consideration by the U.S. Supreme Court for direct review. In other words, the Supreme Court is considering taking the Virginia case right up without going through the 4th Circuit. And if they do that, if they were to decide to take that unusual step, they might very well decide to take the case from the District Court in Florida as well. So we're watching that carefully. The Supreme Court will make its decision one way or the other, we think, by the end of April. The second issue I wanted to cover is the issue that's in this lawsuit, which is the individual health insurance mandate. 28 states have challenged the mandate as being an unconstitutional exercise of congressional power. In short, we don't believe Congress has the power to order the American people to spend their own money on a commercial product in the private marketplace. It's without precedent in U.S. history. Congress was warned by its own research service, the Congressional Research Service, that it was problematic, that it raised a number of questions. And sure enough, all 5 courts that have considered the health insurance mandate have treated it as a serious constitutional question. Some have upheld it, some have struck it down. All of them have said this is a real issue. The mandate would require you by 2014 to prove to the Internal Revenue Service not only that you have health insurance, but that you have the health insurance that the federal government says you have to have. We don't know what that will be yet because Congress is leaving it to the Department of Health and Human Services to decide what qualifies as health insurance satisfying the IRS requirements. But it points to the fact that a lot of these decision-making powers are being left to these bureaucracies that the new law has empowered or created. So that's what's at stake here. It's a question of whether or not, for the first time in American history, people of this country can be ordered to buy a private product in the commercial markets or not. Judge Vinson, in his opinion in Florida, in striking down the mandate, pointed out that if Congress has this power, then they have the power to do pretty much anything else they want, without regard to the distinctions between the federal government, the state government, and us as individuals. He pointed out that there would be nothing to stop the federal government from, for example, ordering us all to eat a certain amount of broccoli a year. Obviously, that example is somewhat tongue-in-cheek, but it has a serious purpose, which is to illustrate that there's no limiting principle on federal power under the federal government's argument that they can order us to go in and buy a commercial product with our own money. That's what's at stake here. It's really a question, as Judge Vinson pointed out, a question about our federalism system and about what the limits on federal power are. So we look forward to seeing what the 11th Circuit has to say about that and what the Supreme Court has to say. As I already mentioned, we may see a decision by the end of 2012, or it could be in the 2012-2013 term. We should know more about that in the next several months. Thanks a lot for taking the time to watch this video and to read the frequently asked questions. We'll talk to you when there's something else to report, and we'll provide a new video update. Thanks again.